Damn it, Janet, stop charging by the hour.
There, this is Janet Gershon-Siegel from Semantic Shenanigans, and this is another extra. I had wanted to talk about this. It's in the Dr. Seuss Enterprises case versus ComicMix and David Gerald et al. There is a new amended complaint. And the truth is, amended complaints and pleadings and whatnot in most cases aren't really that exciting. And we did talk about this last month. The main thing that they did was they removed a claim for trademark infringement because that got knocked down. And that's fine. And what also happened is that the plaintiffs gave some background as to kind of the ramp up to the case. Basically, what they were saying was, this is some of the history that happened right before, so in order to give not only the court an idea of what may have been done in order to prevent a lawsuit from happening in the first place, but also to give this information to a potential jury. Now, they have the exact same side-by-side comparisons, but these comparisons are coming a little bit later in the document, which has gotten longer. And again, it's because of all this foundation that they're laying. One of the things that they did in laying the foundation is they talk about the fact that Dr. Seuss Enterprises does grant licenses on occasion, and they even showed some of the products that are licensed. And I would say, truthfully, if this case got as far as trial, and there's a jury in front of it, then Dollars to Donuts, one of the plaintiff's attorneys, and maybe even more than one of them, is going to try to make the argument that there were licenses. They were pretty obvious, and there were clear methods of doing so, and that defense should have tried to do that. And that's and that's a really good argument. You know, here this is, it's out here, and you should have done this, and you should have known it was possible. In particular, because the defendants are people like not just ComicMix, but also David Gerald, who was certainly known in Star Trek circles. This is somebody who absolutely knows what licenses are and should have had at least a concept of that, and they should have at least tried. And certainly, there's no evidence that they tried to. Now, the other thing is that, other people have commented on this, and I got to say, I think they're really clutching at straws with some of this stuff, because it's just really not as remarkable as you might think. But I wanted to comment on it just to address this particular piece of this new pleading. And the thing that came up is that there were a couple of cease and desist letters. The first one is mentioned on page 19, paragraph 50, and it states, and I quote, "After learning of defendants' unauthorized use and planned uses of the Dr. Seuss intellectual property in the infringing work, on or about September 28th, 2016, the undersigned counsel for DSE," that's Dr. Seuss Enterprises, "sent defendants a letter asserting DSE's exclusive rights in the Dr. Seuss intellectual property and stating that defendants' use thereof was an infringement of DSE's rights. The letter demanded that defendants immediately cease all use of the Dr. Seuss intellectual property," end quote. So basically, this is a standard cease and desist letter. Dr. Seuss Enterprises throws down the gauntlet. It sends a note to ComicMix and says, "You're using our stuff and you don't have permission to do so. Cut it out." But defense doesn't knock it off. So instead, what happens is, this is mentioned on page 20, paragraph 57, A month later, the defense fires back. So it says, and I quote, on or about October 28th, 2016, counsel for defendant ComicMix sent a letter to the underside counsel for DSE responding to DSE's October 7 takedown notice to Kickstarter. There was actually like a second little bit going in there that was just straight to Kickstarter. Refusing DSE's demands to cease all use of the Dr. Seuss intellectual property, threatening to pursue claims for tortious interference, unfair business practices, and violations of 17 U.S.C. Section 512F, and advising the defendants would be sending a counter notice pursuant to 17 U.S.C. that's U.S. Code, Section 512G3 to Kickstarter to reinstate its campaign. Just to give you a little background here, 17 United States Code, Section 512, is referring to the limitations on liability regarding to materials online, or as you've probably heard it, it's called in common ordinary parlance, it's called the Digital Millennium Copyright Act, the DMCA. So basically what happened is plaintiffs sent a letter in September, and then they also send a notification to Kickstarter in the beginning of October, and then late in October, defense fires back. Defense also said they would file a counter notice. So basically what happened here is that that plaintiffs kind of got slapped on the hand for trying to do the right thing, which was to inform the defense that, hey, they're we might be suing you. So this is so keep that in mind, that there are reasons, and I'm going to get into that in a moment. There are reasons why you might not want to file a DMCA takedown notice. You see in the Z&A desist, cease and desist letter, and this is one of them. It's that there was a complete waste of time, and it also kind of spurred the defense to say, hey, well, we're just gonna come back and we're gonna counter sue you. Now, what CBS did further down on page 20, paragraph 59, it states, and I quote, on or about February 27th, 2017, counsel for CBS Studios, the owner of the intellectual property in Star Trek, sent defendants a letter asserting CBS Studios' exclusive rights in the intellectual property in Star Trek, and stating that defendants' use thereof was an infringement of CBS Studios' rights. The letter demanded that defendants immediately cease all use of the intellectual property in Star Trek, end quote. Now, CBS has not joined in this lawsuit, so there's a few possibilities as to why. One of them is that they may have done a lot of research and said, it's our case, maybe it's not so hot. That certainly Dr. Seuss Enterprises has a much better case, because after all, you can see what really does look like wholesale copying. And if you ever want to look at any of the documents, please ask me. I'm more than happy to send them to you. I got them. I'm happy to give them to you for free. You are a member of the general public. You have a right to know this is a public matter. So one of the reasons why CBS might not have joined this case is they might have looked at their arguments, and done legal research. I assume that they did, because that's why you have a legal department. And their lawyers said, Dr. Seuss Enterprises really has the infringement case. What they may be able to say back to us is that there's a defense of parody or satire, and they might be successful, or that they have a very good chance of being successful. So it's imperative, it's important for for CBS's lawyers to bring this back to management and say, we don't think this is such a hot case, and, you shouldn't pursue it because this is going to waste your money. The other thing is that there's a very real possibility that maybe that didn't happen. And maybe CBS's lawyers are saying, hey, we probably do have a pretty good case here. But they're waiting and seeing exactly what happens potentially before joining in as a plaintiff. It's one or the other. It's most likely one or the other. It's highly unlikely it's anything else. So but the defense didn't cease and desist against Dr. Seuss Enterprises, so they obviously have not ceased and desisted, it's hard to say, against CBS as well. So also their letter has been ignored, but at least they didn't get a, counter notification, or at least we don't know that from the pleadings. Now, why people are going nuts about this is that they've kind of circled back and said, oh my God, this means, look at that, CBS and Paramount, they didn't send a cease and desist letter to Alec Peters and Axanar. Look how horrible and unfair that was, and they filed suit instead. So the question was, why didn't they send a cease and desist letter to Axanar and Alec Peters? Well, the fact is, they didn't have to. It's not a requirement here. A cease and desist letter is absolutely not a prerequisite to filing a case for intellectual property infringement. So you skip the step or you go through this step. It doesn't matter. It has nothing to do with whether you'll win the case. It is not one of the elements of the case. So you could have just skipped it. One reason is, why would you skip a C&D? Well, if the defendants are just going to ignore it, if the recipient's just going to ignore it, then why bother? It's just a waste of time. Another reason is, what if the infringement is ongoing? If an infringement is ongoing, then if you send a letter on, let's say, January 1st, just to pick an easy day, and it's received on, let's say, January 6th, and then you got to give it a couple of weeks for them to reply and all this other stuff, you're getting into mid-February and maybe mid-March. If you're losing money on a daily basis, then all of these delays, all they're doing is they're costing you bucks. So why bother? Granted, bringing suit also costs you money. But if you're certainly bringing suit in order to try to get this stuff to stop as well. Another reason is, as was kind of mentioned a little further up the chain, in the Seuss case, the defense actually said, we're going to go after you for tortious interference, and we don't like you, and we're going to do things back to you. So there's potentially a situation where the recipient tries to file for what's called a declaratory judgment, and this is a It's called an equitable remedy. There used to be a real difference between law and equity in English law, and it comes down into the United States, and then it mostly goes away except for a few jurisdictions, two of which are New Jersey and Delaware. Delaware has a real live equity court. But most places don't. Most places combine them. And I'm just going off on this little tangent here, only because it's kind of nifty, and also because I went to law school in Delaware. But and I might add, having the equity court is one of the reasons why there's so many corporations incorporated in Delaware, because they get their own, pretty much it's their own court. But be that as it may. It's an equitable remedy, which means it's not really for money. Equitable remedies can be for money, but it's very rare that they are. They're usually for performance of some sort. And so when you file for a declaratory judgment, what you're basically saying is you want the court to judge, to preliminarily say that this is okay, that they're not in violation of copyright. And while it's certainly possible to fight such things, this would have created a lot more headaches for the plaintiffs. So if the plaintiffs thought that was going to happen, then there's really no good reason to send a C&D, and in fact, a C&D can harm you. Now, there's also a question of fairness. People have asked, "Oh my God, this is so unfair! They sent it to ComicMix and they didn't send it to Axanar. Oh, how horrible!" Well, allow me to circle you back a little bit. I want one thing to be really clear here, which is that copyright infringement is not just this one big piece that's always the same. You don't treat every case the same. You don't treat every single infringer the same. That's not a lack of fairness. That's a practical matter. Big infringements require bigger work against them, basically, or things that are ongoing, or stuff where you think that you can make a good precedent, or where you think that there might be others that are waiting in the wings that you're going to affect. Those you're going to actually, do a lot more work on and be a lot more vigilant about, and send out C&Ds, and do more and more and more on. But others you might want to just move in to the lawsuit immediately, and in others it might just take a letter or two. So and not even a formal C&D letter, maybe just a note saying, hey, knock it off, and the person says, okay, I cry uncle, that's fine. If you treat it, it's the old expression, if your only tool is a hammer, then all you see are nails. You've got other tools here, and that's really what happened, is that one tool was used in one instance, another tool was used in another. And one thing I want to point out is that there is such a thing as overkill in these cases. I'm going to draw your attention to a case that came down fairly recently. It comes from, it was in the circuit level in 2015. It's called Lenz, Lenz, versus Universal Music Corporation. And in the blog post, I've got the citations and whatnot, and the stuff that they were suing and getting upset about. What happened was, in the Lenz case, it's a 30-second, actually I think it was like 29 seconds, YouTube video. The sound quality is horrible. It's really, really bad. It's and so is the video quality, I might add. It's just a really terrible video. It's a toddler. I want to say the kid's, I don't know, maybe he's 11 months old, something like that. He is, he's got like one of these like toys where you can hold on to, and and it rolls, so it sort of helps him to learn to walk. And there's a little bit of music playing in the background, and it doesn't even play for the entire time period. So we're talking about music that plays for maybe, I want to say, 14, 15 seconds of this. Certainly not a masterpiece of cinema. And and you can barely hear it. It's barely on the edge of hearing, and it's Prince's Let's Go Crazy. Stephanie Lenz, she's the mother, she's the one who did the recording. She received takedown notices from Universal because, you want to know why? Because the artist known as Prince said, I don't want that. And he told them to jump, and they said how high, and so they sent C&D notices. This is nuts. Let's face it, that was absolutely, it was overkill. It was crazy, literally. Because after all, like I said, it's a very small amount of the music, and you can barely hear it, and it's not being used to sell anything. There's no commercial usage here, which also goes against fair use, right? Because we've talked about fair use before, and when you have a commercial use, it's very unlikely that you're going to have fair use, whereas if you have a non-commercial usage of intellectual property, you've got a much better chance of being able to prove that there's fair use. So the courts agreed with Stephanie Lenz, not with Prince. The court said the DMCA takedown notice never should have been sent without the company first considering the matter of fair use. Now, I'm not bringing this up in order to argue fair use here, because I don't think that ComicMix was performing fair use, and I also don't think that Axanar was performing fair use. Both of them were doing it for commercial purposes. Both of them were borrowing quite a bit of stuff. Both of them were trading on the fact that these things were really obvious, and that there was a built-in audience for them. Basically, all they would, and both of them had the opportunity, at least, to inquire into licensing, even if they wouldn't have gotten it. And neither of them did so. And both of them profited from this, or at least attempted to. And both of them were doing this because they knew that they would get attention and interest from people who already had attention and interest in these particular pieces of intellectual property. And so as a result, they were piggybacking on and basically leeching off the hard work of the people who had originally created the IPs. So I'm not talking about fair use for them. Like I said, I don't think either of the defendants in either case were doing fair use here, whereas I think Stephanie Lenz absolutely was under the umbrella of fair use. I'm not saying that. But what I am saying here, what I'm arguing here instead, is that some infringements are a lot tinier than others. Prince certainly could have used a lesson in perspective and degree here. If you were making a business decision about this stuff, and if they had, been a little smarter at Universal and said, okay, yeah, Prince you want that? All right, let's go get a latte and we'll talk about this. A smart business / legal decision that's made after research and discussion and meetings and thought about this stuff. One business decision went one way, which was to send a cease and desist letter to ComicMix. And I'm talking about CBS doing this. And the same sort of discussions and research was done in the Axanar matter, and they decided not to send a C&D letter. Now, possibly they thought that ComicMix would comply. It's possible that they thought the infringement wouldn't be ongoing, or maybe they felt, like I had mentioned earlier, that a parody defense would have too good a chance of being successful, so they didn't want to take that chance. I want to pull back on, because there's still people who say, oh my God, look, Prelude and Axanar was so wonderful and amazing. It was a big threat to CBS and Paramount. They were scared. They were shaking in their boots. Something? These are multi-billion-dollar corporations. They're not scared of you. They're really not. 1.4, 1.5, or $1.8 million, whatever was actually raised when all is said and done, and when the books really are looked at, and the math is really checked by people who actually know what they're talking about and are using proper accounting methods. Even when you look at all of that stuff, that's still a drop in the bucket compared to what CBS and Paramount can actually make. And I might add, it's a drop in the bucket based on what the Star Trek intellectual property is actually worth. No, they didn't. They weren't threatened by you. Instead, like I said, there were differing degrees of infringement, differing potentials for harm. And Axanar, the reason why they went after Axanar and they sent them a lawsuit, they were served with process rather than sent a C&D letter, is because it was ongoing infringement. Because it already was ongoing. It had gone on for a couple of years. It had branched from not just making a film, but it got into a donor store. There were ideas kicking around about books and games, a series, a convention. They were looking to sell tunics. They sold models. They were selling busts, sculpted busts of the people who had been in Prelude. They were selling all sorts of tchotchkes, and it even went to coffee, which, the licensing deal might have been a little, there was no licensing, but they attempted actually to sell a license to another individual, or at least there was a discussion about that, and forgive me, but I don't remember the exact precise detail of that. Plus, they were billing themselves as quote-unquote an independent Star Trek film rather than a fan film. They paid salaries to the people who were there, and these were beyond the minimum required for SAG, that's Screen Actors Guild, and they didn't show any signs of letting up. Therefore, the business decision made by CBS and Paramount differed from the one that was made to ComicMix. And in the Axanar matter, the decision made by CBS and Paramount was to go ahead with a lawsuit. And for the people on the Axanar camp, who were saying, "Oh my God, if they had told us to stop, we would have stopped." I hate to break this to you, folks, but when you're served with process and you're being sued, you're being told to stop. So if you ignore that as well, then I don't know where to go with this. I mean, and it's funny because I've seen both sides of this, okay? Where they're saying, oh, yeah, they should have told us to stop, and then we would have stopped. But then I've also seen the exact same people turning around and saying, well, when you're told to stop, you don't necessarily do so if you think you have a defense and you think you got fair use and stuff like that. Which one is it? But be that as it may, it doesn't matter to the sense of fairness or propriety or anything like that. The law did not require that there be equal treatment for these two infringers. Ethics does not require that there be identical treatment for these two dissimilar infringers. They really aren't the same, I might add. And morality doesn't require it either. So let's get off that high horse, folks. They treated two separate infringing situations differently because that's reasonable. Because not everything is the same. And let me tell you, Stephanie Lenz would be the first person to tell you that some degrees of infringement are just not like others. Once again, this is Janet Gerson-Siegel for Amended Shenanigans. Thank you so much for listening. And we'll be back with episodes sometime after the summer. But I hope you're enjoying the good weather. Thanks. Bye-bye.
Music provided by Invocation Array. Send mail to hosts@semanticshenanigans.com. Follow us on Twitter at 2shenanigans. That's the number, not the word. 2shenanigans. On Facebook, you can find us at Semantic Shenanigans. Subscribe to our YouTube channel, Semantic Shenanigans. Thank you for joining us, and we'll see you next time right here on Semantic Shenanigans.